Chatsworth Superior Courthouse. William Wagener here for On Second Thought. Again, we're at the Chatsworth Superior Court, and we're going to go talk over to that man with the feather in his cap. His name is Bill. We just witnessed Dan Bersati's very cordial greeting by Judge Fowler in Department 49 here on the 9th of October. Very civil judge. He's the most polite judge I've seen in the last 20, 30 court cases. Let's go talk to Bill and see what really happened here. Okay, Bill, tell me what you observed here in Mr. Dan the Man Bersati's case.
Well, it was a very cordial proceeding. Either the judge did not read his paperwork or the judge decided to test Bersati and ignore it. So it's clear that it had to be one of those two things. Bersati did his paperwork, I've looked at it, and it looks very good to me. It looks like I think the judge has to follow an agenda, and if he doesn't, he's in trouble. This judge started off well in the beginning, but as the case progressed, he did a flip. And they must have gotten to him, you know, that's all I can say.
So would you say Dan had a win today? Because they're not coming back till January.
Oh, not a win. What Dan did was he made the appropriate objections. And so after the objection, the judge should have given consideration. And at one point, Dan said, when asked why he objected, he said, "It's not my wish." And that was a correct response, because that court is Dan's court, you see. And so the judge is, at best, a counselor to the sovereign who owns the court. The people are sovereign, you see, and that's all in black and white law. So
in black and white law?
Yes, it is. It's all documented.
So the words, "it's not my wish," those very specific words,
yes,
have more importance than they would appear to the average person.
That's correct. This is actually a tradition that goes back thousands of years by King.
And you really should push the start here button.
Yeah. Now, there is a search function up here, right about here on the screen. So if you're searching for something, you can search the website. But for the beginning person, what you do is you click on Start Here, which is located right in this black area.
Okay.
So Start here in big letters. You click on that, and that takes you to the core page. And on top there are instructions. If you follow the instructions strictly, then you should be able to complete the reading of everything in about a week.
A week?
Uh-huh. Because there's a lot to absorb. But it's about a week. It's not much time when you think about getting a legal education. It's very short in terms of, there's a lot of information. So what we will do is, as we talk, I'll sort of step through these menus, and we will expand on the subject on each one. And some links to information. It's very important to have the right attitude when you go to court. If you have the wrong attitude, you'll get in trouble. If you have the right attitude, you might get in trouble, but not as much. You don't have to listen to it. It's nice, but it is a goodly length of time. You know, it's important to understand what that's all about. So we have some discussion about language and dictionaries.
Got it.
What is dishonor? Because these are important things in the court process. When you dishonor your opponent, then you basically lose your case. So you always want to be in honor. Which one are you? We have two kinds of humans in the United States, and that's constitutionally defined. You have people and you have citizens. And it's important to understand which one you are. For your information, the Bill of Rights does not create any rights. It only acknowledges what already exists. Furthermore, the Bill of Rights do not apply to people. They only apply to citizens. And basically, they're a restriction on government. They don't grant anything, but rather they restrict government. Who's sovereign? Why are you sovereign? And everything on this website is backed up by black letter law, by case law, or by irrefutable logic. It's so obvious that nobody would deny. Next is the difference between a republic and a democracy. Very important. This is one of there are 3 pillars in this system of thought, and one of them is the fact that the country is a republic. The other 2 are, you have sovereignty, and you have what's called a court of record. Those 3 things put together is what makes the system work. Judges are lawbreakers. Okay, we have a copy of California's admission to the Union, and all the states have to have an official admission to the Union, and all the states have to be republics. So we have a copy of
what common law is.
Yeah, the essence of common law. And by the way, this is all subject to future research. You know, in law, a lot of times things get modified. You know, perspectives get modified. The definition of a court, just exactly what is a court. So we'll get into that. There's a page which goes into a full description of what a court is. And we're talking about the real world definition of a court as opposed to the legal definition of a court. Okay, so this page, the next thing is, well, what kind of court is it? And there's many different kinds of courts. There's the Court of the Exchequer, there's the Admiralty courts, the Maritime courts, the civil courts, the criminal courts. But the best court, from our point of view, in terms of half dozen more, is court.
A what?
A nisi prius court. That's a court that exists because you failed to object to it. So,
I haven't heard that since I was in law school.
Yep, that's a court that exists because you failed to object. Has 5 requirements.
What are the elements, the 5 elements of a court of record?
Actually, there's 4.5 elements. 4 are mandatory, and the 5th one is optional.
Generally used as a seal.
Yes, that's the optional one.
Power to fine or
imprison for contempt.
And
keeps a record of the proceedings, proceeding according to common law procedure, and the tribunal is independent of the magistrate who's conducting the proceedings.
Superior Court versus Inferior Court.
Right, and the Superior Court of California is a Superior Court in name only. It actually is run as an inferior court. But it could be a Superior Court if they ran it the right way. Okay, so that's by order of the Congress.
Tax court is a court of record by order of Congress.
Right. That means when you get your 90-day letter, you open up your court. The United States is the respondent, okay? And it's your court. You're the judge. Anywho, you got that one right?
The rules about court etiquette.
Correct. Courtroom etiquette. Things that are customary over the centuries, and you know, there's a reason why we take our hats off when we go into the courtroom, a reason why we stand up when the judge comes in, and so forth. A lot of people are in rebellion against that, but frankly, it's part of long-term custom. This corpus. And by the way, you won't find this definition in the law books.
Won't find this in the law books?
Nope. You'll find it in the historical books, but you'll also find it here. I did my research. Okay?
Yep.
Carta. The Great Charter of English Liberty.
And it matters in the United States because of why?
Yeah, it's good law. It's common law.
Common law. Mm-hmm. The foundation of the common law.
Yep. Order of King Edward in the year 1297. And that, by that order, the government must accept the Magna Carta as the common law if the defendant demands it.
Only if the defendant demands it?
Yeah, if he doesn't demand it, they're free to go whatever direction they want.
Wow.
Okay?
Yeah, got it.
brief interpretation of the Magna Carta and Confirmatio Cartarum, explaining how they work together and some of the provisions. There are some interesting provisions in the Magna Carta. By the way, I said finally, I really didn't mean that. An example, okay, complete with a case law and transcripts on a case where a judge is found in contempt of court.
By the plaintiff?
Yep.
And did he go to the Huskow?
No, he did not. It wasn't that kind of conviction. It was a very soft kind of conviction, but it got the message across. We had a record of a court case. In this court case, we actually issued a bench warrant for the arrest of a judge. He wasn't arrested, but he changed his attitude. Worked very nicely. And also as a suggestion for the strategy and also a sample counterclaim and a sample law of the case. That's over here on the left side. Where this comes from is it's actually long-term tradition for thousands of years. The problem is this: the barbarians brought in the concept of the divine right of kings. And so God speaks through the kings, according to that theory. And whatever the king says and does, that's the law. That's how things are. So the problem is that the theory puts absolute authority into the king, yet the king is human and his subjects are human. So there is such a thing as human resentment. So if a king becomes too officious, he could end up eating arsenic. You know, his subjects may not like him.
Yeah, I get that.
So to soften the situation, they developed the custom that the king never referred to himself. He always referred to himself in the third person. So he would say the king wishes something. And also the fact that he wishes something was actually a command, but it didn't carry the heavy weight of an actual command. It softened the message, and that helped the king to live longer. So there's a lot of competition for kingships. Anyhow, there's a need for education. The Beagles have worked very hard to obfuscate the information. So we have here the Nitty Gritty Law Library. The website is 1215.org. That's 1215.org. And I'm the curator of the library. The purpose of the library is to educate people. The information on the library is free. The library has a mission. The mission is, through the courts, encouraging the government to obey the law. So the idea is that we're not rebelling against the system. In fact, quite the opposite. We want the system to work. What we're against is the abuse of the system. So that's our whole theme here. So starting at the top, I refer to, and the first thing that I want you to see is the Serenity Prayer. This is a great prayer, not so much the religious value as it is the secular value. It says, God grant me the serenity to accept the things I cannot change, courage to change the things I can, and wisdom to know the difference. Now this is a big problem with a lot of patriots. They don't have the wisdom to know the difference. They get locked into some sort of ideal and they actually do themselves harm. So I'd like to correct that. Think of it this way. Let's say you're a pedestrian and you're about to cross the street. You have the right of way. But just as you're going to cross the street, you see a car coming and it's obvious he's not going to stop. Now you have a choice. Should you enforce your right and get killed? Or should you yield your right and let the car pass by? Now that's an extreme, but that is the basic problem. Many people who are dedicated to their own rights fail to perceive when they were overpowered by the system or by people who are abusing the system. So you have to know when to retreat and when to advance. A perfect example of that was when Napoleon was attacking Russia. And the young lieutenants in the Russian military were all for going in and attacking the world's strongest army at that time. And the general of the Russian army kept them in check and wouldn't let them attack. Instead, what he did is he burned the countryside so that Napoleon's army could not live off the countryside. Napoleon's army developed very, very long supply lines as they advanced into Russia. By the time they got to Moscow, winter set in, the supply lines couldn't move, and the Russian army went in and beat them. The general understood the importance of losing battles but winning the war. And so you've got to understand this. So this is why I bring in the Serenity Prayer. That's the message. I want you to have the wisdom to know the difference between changing things that you can change and recognizing things that you cannot. The next thing is health. Health is very, very important. There's the World Research Foundation, which I refer people to because for $60, at least that's what the price used to be, you could get a complete report on alternative medicine for just about any disease you know about. So it's a good resource to get. It's not a perfect resource, but it sure gives you a doorway into a lot more information. Distilled water, I'm a proponent of distilled water. Just simple distilled water. You can buy it in any store. They sell it. Usually, I guess people use it to put in their iron so that they don't cake up from the minerals. But in reality, distilled water is pure water. If you take water and fill it up with sugar, eventually it becomes so saturated the sugar won't dissolve anymore and it just settles to the bottom. You can do the same thing with salt. Well, what we're talking about is what the carrying capacity of water is. So if you use ordinary water, part of the carrying capacity is used up by the minerals. Now those minerals that are normally in city water or even in mineral water that you might buy in the store, that uses up some of the carrying capacity. So the water cannot carry much more. Well, when you drink distilled water, what you've done is you've provided absolutely pure water. It will carry more food from the stomach to the cells, and it will carry more waste matter from the cells outward. So if you have a medical condition, my suggestion is you drink distilled water only for your liquid, and that will help your body to more efficiently process food.
I get that. Are you trying to help the patriots outlive the crooked judges?
It's advisable that you do.
Okay.
Another thing is that if you feel chest pains, you know the classic symbols, pain in the left arm and chest pains, drink a glass of water, preferably distilled water, but at least drink a glass of water. There's a good possibility that the reason you're having a heart problem is because of the concentration of electrolytes in the bloodstream, and that will help to thin it out. I know that I myself have had a lifetime of symptoms sometimes that come along, and those symptoms disappear within 15 minutes if I drink a glass of water, or maybe 2 glasses of water. So these are all just little suggestions that I've come across.
On 1215.org.
It's on 1215.org.
So getting to the common law and why it's important for Dan the Man, also known as Mr. Barsati,
Wow.
by the magistrate or judge who's sitting on the bench who thinks it's his courtroom. Why is the common law relevant to Dan the Man's case?
Well, the common law is the highest law of the land. It supersedes the statutory law and the code law. Now, if you go to the codes, typically, like I think the California Code, I forget whether it's the Code of Civil Procedure or if it's a civil code, but I think it's section 22.2, which says that the common law shall be the rule of decision unless there is a code to override it. It doesn't say that in those exact words, but that's basically what it says. To best understand what's going on here is, think of it this way. You have a home and I have a home. Now, if I'm visiting you and I want to use the facilities in your house, I would ask your permission first, because me as a guest in your house, I would be subject to your law. Call it the law of the domicile. On the other hand, if you're visiting my house, then you wanted to use my facilities, you would ask my permission first, and you would be subject to the law of my domicile. So the question is, which domicile are you in at the time, which set of laws you follow? Well, you have a similar thing in law. You have common law, the common law house, and you have the civil law house. Or you might have the admiralty law house. Or you might have the law of the exchequer or something like that.
Got it.
So what happens is, if you look at the codes are all civil law, Roman civil law. So they say in their codes that the common law shall be the rule of decision unless there's a code that overrides it. Well, that's because you're in the code house. But if you go to the common law house, then the codes can be the rule of decision, meaning how you make decisions, unless there is a common law to override it. So which law takes precedence depends on which house you're in. Now, how do you select which house you're in? It's all in your paperwork. If you start off quoting codes and statutes and sort of stuff, you put yourself in the civil law house. But if you do common law, you start off that way, then it's the other way. So they're not wrong when they say that the common law is a rule of decision unless there's a code. So it's important to know which house you're in when you run your case. Now, what I'm going to do is I'm going to go through a regular building of knowledge. I'm going to 1215.org, then we click on Start Here, and that page has a set of instructions which basically tell you to step through each page, each link that's on that page, read it, and then return back to this page. And you will get a well-structured presentation of the law. But we're going to do a quick run through it right now. This is not everything. What you really need to do is go to the website and read thoroughly each page that you come to when you click on the links. So the thing we're going to talk about next is language and dictionaries. Which language do you speak? In America, we all speak 3 languages. The first language that is the street language, the slang. When we communicate with each other, we have our own shortcut method of talking sometimes. For example, if somebody walks into a room where there's a party going on, the first thing he might say, "What's going on?" Or he say, "Hey, what's coming off?" Now, what's coming off and what's going on look like they have opposite meanings, but in slang, in the street language, they mean exactly the same thing. It means you want to know what's happening. So in America, we have 3 languages. One's called slang, the other is formal English, and the third one is court English. So in formal English, the language is more universal. Somebody from the West Coast can talk to somebody on the East Coast and communicate perfectly well if he speaks formal English. In legal English, that's more stable than the other 2 languages. Words get defined 100 years ago and they mean the same thing today. Or if the meaning changes, you look at when the document was written and you use the meaning from that period of time that it was written. One of the most commonly misunderstood words by people who are not educated in law is the word resident. What is a resident? Well, the normal person, you ask them that and they'll say, well, a resident, it's where you live. It's where you live, you work, and so forth. And that's true in formal English or slang, but that's not true in legal English. In legal English, when you're resident someplace, That means you're there to accomplish a specific task, and when you complete that task, you'll go home. A perfect example of that is when a doctor does his residency. He goes through college, he gets his college degree, but he's still not allowed to practice medicine. Instead, he goes to a hospital, he does his residency, which means he lives there while he's learning the practical side of doctoring. And once he passes certain requirements, then he leaves the jurisdiction of the hospital and he goes out and he does his practicing. He goes home. So this can be tricky because let's say I ask you, are you a resident of California? And most people would say, well, yes, of course. Well, that means you came to California, and when you finish your task, you're going to go home. Now, where is home? Well, my next question is, are you a citizen of the United States? And the person typically will say, well, yeah, of course. Well, being a citizen of the United States means your home is Washington, D.C. So the Constitution authorizes the Congress to regulate interstate commerce. Well, if you cross the state line and took up residency in California, then you're subject to regulation by the Commerce. That means you have to have a driver's license, or that means you have to have whatever other things they throw at you, as long as you admit you're a citizen of the United States and you are resident in the state. You'll notice in all your driver's license applications, they want to know, are you a resident of the state? That's why, okay? Now, what I did when I was first studying law, and by the way, I'm not an attorney, I've never been to law school. I spent a few thousand hours in the law library. But when I was studying law, one of the things I did is I took a copy of the Constitution and I pretended I did not know how to speak legal English. And so every word that I came across, I pretended it was the first time I'd ever seen that word in my life. And I went to a set of books called Words and Phrases. And that's a giant dictionary with lots of volumes. And I would look up the word. And take, for instance, the word to, spelled T-O. You'll find several pages of court cases where they argued over the meaning of that word. So that's how I learned to speak legal English. So it's very important that you understand, do not assume you know what a word means. Make sure when you come across a word for the first time within the context of law that you look it up. Look it up in the law dictionary. Make sure you understand what that word means. These people that use words like duly, okay? Something was duly done, whatever it is. What does duly mean? Well, it turns out duly that's spelled D-U-L-Y. That means that it satisfies the requirements of both the common law and the civil law. Okay, that's what duly means. So don't just toss around a word unless it says exactly what you mean. Okay, so that's language and dictionaries. Now we have what's called honor and dishonor. This is an extremely important concept in law. You see, when you have an interaction between two people, you must stay in honor if you want to be successful in the interaction. As soon as you dishonor another person, the thing falls apart. So there's two ways to dishonor somebody. You either argue, nonsensically maybe, or the other way is just stay silent. They make a request of you, they make a demand, whatever, and you just stay silent. You're dishonoring that other person. Now, you want to stay in honor. So there's three ways to stay in honor. The first way is called accord and satisfaction. Let's say the dentist sends a bill to you and he says, I pulled your tooth and you owe me $200. Well, you agree with the bill and you pay it. That's accord and satisfaction. So that terminates the issue right there. But let's say that you want to sell your house and the person says, I'll buy your house provided that you paint it blue first. that was a conditional acceptance on his part. If you paint the house blue, you've completed it, your obligation, and now he owes you money. So that would be a conditional acceptance. And finally, the third way to stay in honor is to reject without dishonor. In other words, you're not arguing and you're not staying silent, but you are rejecting it. A good example of that would be, let's say that somebody mows your lawn, okay? And he only mowed half the lawn. And then he gives you the bill for mowing the entire lawn. Well, you can reject that bill by letting him know that he didn't finish the job, that there's still more to do, but as soon as he completes it, then you'll pay the bill. That is a rejection without dishonor. So judges look at this, and if you're in an admiralty court, which a lot of them are, this is an extremely important deal. You have to stay in honor. Let's say you get two people in court and you've got a stupid attorney and you have a stupid party, you know, in opposition. Neither one of them knows what they're doing. When the judge sees that, he realizes that these guys are not honoring each other. They're dishonoring, they're arguing, but they're not really handling things, not facing the issues. What that does is that opens up the way for the judge to freewheel it. Then he can make any decision he thinks is appropriate for the situation. So you don't want to ever be in dishonor when you go to court. Which one are you? The Constitution of the United States, I'm going to shortcut it a little, but it basically says, we the people of the United States, in order to do this laundry list of tasks, do ordain and establish this Constitution for the United States of America. Okay, it identifies us, we the people. It identifies where we came from, of the United States, we the people of the United States. And it defines what the task is to be done, and then it says, we ordain and establish this Constitution. Ordain means we authorize it, we are the authority that's granting it, and we establish it means we actually put it on the parchment. We wrote it down on paper and locked it in ink, okay? Concrete, if you will. So we the people are the creators of this whole system. And the preamble says, we ordain and establish this Constitution for the United States of America. The United States is two words, we the people of the United States. And the United States of America is four words. And the United States of America is that public trust, a corporation, and its home is in Washington, D.C. So we the people of the United States created this Constitution for those guys over there. Now that makes us the creators, that makes them the created. So because we are the creators, we are not subject to their jurisdiction. A possible exception on that, and I haven't settled this in my own mind yet, but a possible exception to that is if the Congress were to pass a statute which specifically identifies that it applies to the people, then you may be subject to it. Maybe not. Like I said, I haven't researched that out. But in the absence of a specific application, then those statutes and codes do not apply to the people. Okay? In 1868, we ended the Civil War, and they came up with this thing called the 14th Amendment. Now, the 14th Amendment says what a citizen is. It says that if you are born or naturalized in the United States and subject to the jurisdiction of the United States, then you are a citizen of the United States. Now, that created a new class of human. The bureaucrats weren't happy with the fact that they didn't have jurisdiction over people. So they created constitutionally a new class of human called citizen of the United States. Then they turn it around and they ask you, are you a citizen of the United States? Or if you have a form you're filling out where you identify yourself as a citizen of the United States, then that means you have no rights. You are subject to their orders. So it's very important to know who you are. Now, fortunately, there are cases which say that you can be a citizen for some purposes and not a citizen for other purposes. In other words, you could choose whether you want to be one of the people or one of the citizens. Major bookstore in Pasadena, California. A friend of mine was a data processing manager, and he told me that when he first went to work for that store, he noticed that everybody was pussyfooting around the janitor. Seemed kind of strange to him, but he sort of accepted it. Eventually, he found out the janitor owned the store, but he didn't want to run the store. So what he did was he took the job as janitor. He was told what to do, what to clean by the boss, but he had the authority. Anytime he saw something is wrong, he could step out of his janitor position and become the owner, since he was already. Well, we have a similar situation in law. If you're a citizen of the United States, you're like that janitor. You got a lot of bosses. But all you have to do is put yourself in the position of being one of the people, and now you're the boss. Now, that's the theory. Now, in actual practice, administrators of the citizens will put up a fight. So it's not that easy to make your point. But theoretically, that's absolutely correct. You can become one of the people and not subject to the wishes and commands of the powers that be in our system. So you have to have it clearly in your mind, are you one of the people or are you one of the citizens? And the preamble, just to review, the preamble defines people. The 14th Amendment defines citizens. On this website, there is case law where the courts have recognized the difference. So this is what I'm telling you is just in order to save time on this short video. I'm just letting you know these points exist, but they're backed up on the website.
At 1215.org.
That's correct, 1215.org. And a little side note here, if you precede that with HTTPS, S as in Sam, okay, that gives you a secure connection with the website and nobody can intercept your browsing of it. And I also recommend using startpage.com to do your browsing. They provide a way that you can browse privately. Now, we have this thing called the Bill of Rights. There is a book, Constitution of the United States of America, Analysis and Interpretation. Now, that book is a very thick book. It has, I guess, a couple thousand pages. It tells the truth. It's published by the Senate. Somebody has to know how this system is put together. If you get that book and read it, you will learn the real truth. There actually is truth in there. A copy of that book is on the website, so you'll eventually find it if you go looking for it. But on page 900 and something, I think, whatever, but it lists people's rights versus citizens' rights. And you'll find that in the Bill of Rights, which are the first 10 amendments to the Constitution, you will find that amendments number 1, 2, 4, 6, and 8 apply to citizens. Amendments 3, 5, 7, and parts of 8 do not apply to citizens. You as a citizen do not have the benefit of all of the Bill of Rights. Now, these Bill of Rights do not apply to people. And the reason is because people have all rights. They're the creator of the system. There is no authority for the government to take over its creator. So this list here, where it explains which rights are for citizens and which ones are not, basically these are restrictions on government, but government's not fully restricted. I think you can tell from modern court trials, the bail sometimes looks quite excessive. Well, that's because citizens don't have protection from excessive bail, and it says so right on the in that book.
Is there a law case that decides what excessive bail is?
Well, see, the problem is with the word excessive. That's a qualitative term.
Right. So what is excessive in one case may not be excessive in another case.
How you define it. You know, I mean, it's.
Okay.
I do know that when you appeal cases One of the criteria on an appeal case is whether or not it offends the conscience of the appellee judges. And believe me, it's hard to offend their conscience. So, I mean, you know, a lot about law is pretty flaky. You know, what's reasonable? Who's the reasonable man? We hear that concept a lot in law. I don't know what a reasonable man is.
Could a presiding judge pick a garbage collector off the back of the courthouse and bring him in and say, I need you to sit and preside on the case, put a black robe on him, have him go in and be a judge?
Not according to the civil law, but theoretically, anybody could be a judge, theoretically.
And that's true today.
All the sovereign has to do is grant the authority to the person. But see, the judge is not sovereign. And I'll get into that in a moment. Let's talk about sovereignty. What is sovereignty? Well, sovereignty is defined as not being accountable to higher authority. You do it what you want. In America, sovereignty is limited by the sovereignty of someone else. There's an invisible line between two sovereign. People are sovereign. And that invisible line, if you cross over it, you may be pushed back. And if there's a dispute as to where that line is, then we can bring in a jury, and the jury will decide where the line is drawn. So, but the bottom line is that my fist stops where your nose starts. Sovereignty is limited in that sense. Other than that, government does not have, from what I can tell, any authority to limit your sovereignty. It's the other sovereigns that limit you. I will read to you, though, a court decision here in Chisholm versus Georgia. And it says, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country. But they are sovereigns without subjects, with none to govern but themselves. The citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. The government has no sovereignty. State government has no sovereignty. The sovereignty is in the people, the creators. Also, here's another court case that really goes back in time, 1829. This was a New York case. Says, the people of this state, as the successors of the former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. What are the rights of the king? He defines his own rights. So again, anything you say is your rights. Those are your rights, with one exception. Your rights cannot impose on another sovereign's rights. Other than that, there's no limit.
So a sovereign citizen could define a court's...
Stop right there. Sovereign citizen means to me master-slave. How can you be a master and slave at the same time?
Good point. So a sovereign walks into the courthouse,
right,
and defines it as a common law court that he accepts and tells the judge on the bench what you can do and not do?
No, he doesn't accept it. He creates it. Okay? The sovereign creates the court. He doesn't accept the court.
Well, then he could decide not to accept a particular judge.
That's correct. Now, the way that's done, the mechanics of it, because you have to have procedure. And the common law procedure is to do a counterclaim. So when they sue you, you sue back. And the number one issue when you sue back is jurisdiction. You challenge jurisdiction. They must prove the jurisdiction, and they must prove it to you. You are the decision maker. It's an interesting concept. It's a way of balancing the powers. Okay? But we'll get into that in a moment. The next thing I want to talk about after sovereignty is republic versus democracy. What's the difference between those two? Now, this is not taught anywhere, and yet if you look in the law dictionary, it's right there in black and white. So let me first define what a democracy is. Democracy means 51 beats 49. People argue among themselves, they vote, and whatever the majority says, that's the law. Okay? So another way of saying it is that the sovereignty is in the group. The individuals don't have sovereignty. In a democracy, the sovereignty is in the group. So whatever the group says, that can be imposed on the individuals. But the group itself is the sovereign. Okay? Now, a republic is identical to a democracy. there is absolutely no difference. Anything you can say about a democracy, whether it's a representative democracy or a group democracy or whatever you want to call it, those same terms can apply also to a republic. So what's the difference? Well, the difference is that in a republic, the sovereignty is placed in each individual person. Now remember that the definition of sovereignty is not accountable to higher authority. So here's what happens in a republic. The people argue among themselves, just like in a democracy. They go back and forth, say whatever they're going to say, but then they vote. Now, whatever the group says, okay, in other words, majority rule, whatever the group says can only be applied to the people as advice. It cannot be mandatory. The reason it can't be mandatory is because if it were mandatory, the people wouldn't be sovereign. So, in a republic, the people are sovereign. So nobody can tell you anything. All they can tell you is, this is what we think you should do, okay? In a republic, there might be a hole in the road. In a pure republic, you just go out and fix it if you choose to, or you can hand it over to your representatives who have all the equipment and so forth, and they fix the street. Interesting case some time back. It actually never got to be a case, but out in California, in the city of Santa Monica, there was a sign that was somewhat misleading. It was a freeway sign. And everybody agreed that it was misleading, and complaints were made, and the state government never did a thing. One night, somebody sneaked up and fixed it. He had the right color paint. He did everything right. It was a professional job. And so the question came up, well, could he really do that? Well, in the newspapers, that's as far as the question went. But I knew the answer. The answer was, yes, he could do that. California is a republic. And he decided to fix the problem himself. And that would be legal. And he did a good job. So nobody questioned the quality, okay? And I don't think an issue was ever made of it, but the sign got fixed. California got admitted as a republic. The Congress took the application, they evaluated it, argued, whatever. Congress made a determination that California was a republic. They liked the Constitution that California had. That was the 1849 Constitution. And so then they went ahead and okayed it. And so California's a republic. Now, again, I just defined what a republic is. So this is really a key thing. You remember I said there are three pillars in our society and how our legal system, how it works. So one of those pillars is that it's a republic. Okay? The other two are the sovereignty of the people and the court of record. So California got admitted to the Union as a republic. Every state is a republic. Now, some people point to the state of Louisiana and they say, well, Louisiana it doesn't have the common law, that actually it follows Napoleonic law. Well, that's true as long as nobody objects. However, Louisiana is also a republic. And if the people decide they don't want to apply Napoleonic law, then they can define their own law. And the common law is perfectly acceptable. So you can have common law in a republic. The state itself cannot assert common law, but the sovereigns of the state can. Now, let's talk about what common law is. Actually, common law is basically, it's defined as custom and usage since time immemorial. In other words, we do things a certain way, but we don't know when it got started. Its origins are unknown, but this is how we do things. So there's certain obvious things like we don't murder, we don't steal somebody's wife, You know, the Ten Commandments, basically. The Ten Commandments can be common law, but the Ten Commandments existed even before the Bible. There's archaeological evidence that they existed beforehand. So this is common law. The common law also is the Magna Carta, and I'll get into that a little later. But that's what the common law is. So basically, what it boils down to, the common law is anything a jury wishes to impose. That's the common law. Okay. Sometimes the jury is said to be the representatives of God, that everyone has the law of God written in their heart. They know basic right and wrong. So that is the common law.
Is a court?
What is a court? That's what we're going to get into. Now, a court is very simply defined. It is the person and the suit of the sovereign. So when the sovereign decides to sue somebody, that creates his court. Now, to help you visualize it, just imagine that if you were a king or a queen sitting in your throne and you have this court full of people. Those are the courtiers. Okay? And you have, it is, as I said, it's the person and the suit of the sovereign. Now that's modern word terminology. In olden days, and not so very far back, maybe 50 years back, it was the person and suite of the sovereign. Now, you know when you go to a hotel, you get a suite of rooms?
Yeah.
Okay? What that is that's a collection of rooms. So the suite, the person and suite of the sovereign is the king's courtroom with all the courtiers, all these people who gravitate to the center of power. That's the suite, a collection of people. In modern terms, they dropped the E off the end of the word suite, and now it says suit. So it's the person and suit of the sovereign. That's what a court actually is. So a logical question when you go to a court is, well, who's the sovereign around here? Well, you'll notice that when the state is suing somebody, they always say it's the people versus so-and-so. That's because the state has no sovereignty. Okay? The sovereignty is in the people. If you look at the codes, again, I have trouble remembering between the Code of Civil Procedure and the Civil Code of California, but it says right in there in section, I think it's section 100 or 101, somewhere in there, that the sovereignty of the state resides in the people of this state. So that's where the real sovereignty is. The real authority comes from the people and is lent to the state. And we can take it back anytime. All you have to do is file a lawsuit, you just set up your own court. So a court is defined as the person and suit of the sovereign. Now, in olden days, that suite of people was the memory of the court. So when the court process happened, then all these people were witnesses to the court action. And so that was the court record. In modern times, that suite of people morphed into 8.5 by 11 sheets of paper. And now the memory of the court is documented in paper. Okay? And by the way, be careful of the use of the word document. The legal meaning of document means a paper produced by the government. You don't produce documents, you produce papers. That's if you want to get real legalistic about it, real technical. So a court, being the person and suit of the sovereign, when you sue somebody, you're the plaintiff or claimant, there's a number of titles you can have, or petitioner, whatever it is, you are creating your court and you own that court. Okay? Now there's several kinds of courts that you can have. You have the court, you can have a civil court, you can have a criminal court, you can have a court of the exchequer, you can have an admiralty court, it goes on and on. There must be 100 different kinds of courts.
And those are all defined in Black's Law Dictionary, or where would you go?
Pretty much. But the important ones that we're concerned with in order to enforce our rights are the civil court, the criminal courts, and your court. Now, your court can have different formats. You could make your court a criminal court or a civil court, but the best court to have is called a court of record. Okay. A court of record has to meet several requirements in order to be a court of record. As a matter of fact, there are 4 mandatory requirements. First of all, it keeps a record of the proceedings. Second, it is proceeding according to the common law. Third, it has the power to fine or imprison for contempt of court. And finally, the tribunal, that's the one who does the judging, the tribunal is independent of the magistrate who's conducting the proceedings. Now, all judges are magistrates, and in a court of record, a judgment cannot be issued by a judge. The judge has absolutely no authority to make any judgments in a court of record. That job is reserved to the tribunal. Now, who is the tribunal? Well, there are only 2 entities that can be a tribunal. One of them is the sovereign himself. You know, the king's on his throne, and he has his court in operation. He's a decision maker, right? I mean, we all understand that. The only exception to that is if the individual who you're suing wants a jury. A fully empowered jury will take over all of the authority and run the court itself. Now, here in America, we have 2 kinds of juries. We have fully empowered juries and we have advisory juries. An advisory jury simply comes to its decision and advises the court. The court is still free to do what it wants. Whereas in a fully empowered jury, that's it. It's fully empowered. There was a wonderful case I heard about one time. Unfortunately, at the time I heard about the case, I was too young to appreciate it. I didn't have the knowledge or interest. But there was a fellow telling me about when he was a juror. I was a young kid, like maybe 17 years old, something like that. And he was an old guy, probably in his 70s or 80s. But he was telling me about how he sat on a jury, and in that jury of 12, there were 2 people, he and someone else, who really, really understood what a jury was for. And what the case was is that a black man had stolen a couple of chickens, took them home, and they prepared the chickens and they put them on the dinner table. The cops came in, took the chickens off the table and arrested him for stealing, for burglary. So it got to court, and the jury's sitting there listening to it, and it came out in the court that this individual was extremely poor. He had applied for welfare with the state of Mississippi, got turned down, he was destitute, he had a family to support. So the jury looked at this and they said, well, this guy's not really a crook. He actually stole the chickens. Yeah, he stole the chickens, but it was out of desperation. So the right to live superseded the right of property, according to the jury. And it was a fully empowered jury. So the jury came back with a not guilty verdict. Well, that really upset the judge, that really upset the prosecutor, and of course it really upset the victim. So the judge ordered the jury to go back and reconsider its decision, which it did. And when it came back into the courtroom, the jury came back with the same not guilty verdict. And on top of that, they issued an order to the judge, telling the judge to order the state to find this man eligible for welfare and to give him some money.
Wow.
That was the power of a fully empowered jury. Now contrast that with what happened in the Waco case. You may recall in the Waco case when Attorney General Janet Reno ordered the military to go in and burn down the what they called a compound, this religious compound and so forth, and killed a whole bunch of people. Well, there were some survivors, so after that event, they prosecuted the survivors for basically making them responsible for the people who had died. Well, the jury found that they were not guilty. The judge said, no, they are guilty, and gave them 20 years. Well, that's what the judge could do with an advisory jury. So, a jury is not necessarily protection. Now, as a general rule, the judges go along with the jury decisions, but if the case is important enough, they'll override the jury.
So how could that jury in the Waco case made itself an empowered jury and stopped the judge?
It couldn't. The jury was invited in, you see, and the terms were specified. Look at what the judge says to the jury. You got an incoming jury, and one of the first things he says is that, will you, how does it go?
Obey the direction of the court.
Basically, will you accept the law as it is given to you?
Right.
Okay, or you something to the effect. Well, that is an advisory jury. Okay, they don't have independent power. However, the Supreme Court has said that a jury can do anything it wants. But again, if it's an advisory jury, the court is free to ignore it. Now, they usually go along with the jury because they don't want to upset the apple cart. Okay, but if it's important enough, they'll override it.
So how do you avoid that? You have to establish it's your courtroom.
Well,
you have to make it a common law courtroom to begin with, and then demand an empowered jury?
Well, instead of defending, you should counterclaim them, you should challenge their jurisdiction, and you make it a court of record, and it's up to the defense to demand a jury. You don't want a jury because you have full authority. Why would you want to dilute your authority? You're the king of the court. So you make your decisions. Now, if the opposition doesn't go along with that, their recourse is to ask for a jury. And it's up to them to demand a fully empowered jury or an advisory jury. If they don't say everything, if they don't say, then everybody assumes it's an advisory jury. Even the attorneys, even if they don't know what an advisory jury is, they would go along with it. In fact, there's an attorney, very famous attorney, called Jerry Spence. A great guy. I mean, if ever there was an attorney that was on the side of the people, Jerry Spence is it. He won the Pinto case. That was where somebody rear-ended a Pinto and the gas tank blew up, and it turned out that for economic reasons, the Ford Motor Company knew the defect was there, but it was cheaper to pay out the lawsuits than it was to fix the problem. So he won an extremely large lawsuit, and the judge cut it down, and I remember Jerry Spence saying, well, how can he do that? Jerry Spence, as good an attorney as he is, did not understand the concept of advisory juries. Attorneys are not trained that way. Okay? You'll notice that the training of attorneys tend to be in favor of the power of the government.
I've noticed that.
Yes.
And Jerry Spence has too. He's since moved from Jackson Hole, Wyoming to Santa Barbara.
Oh, he has?
Yep.
Really?
Yeah, I met him and taped him after a protest.
Okay, he's one of my heroes.
You should see that video of him speaking, and it's short. It's only 3 or 4 minutes.
Well, that's great.
So,
would you like to state on here what website to go to in order to look at your videos?
To find that video, you'd go to youtube.com. In YouTube search window, you put in William Wagener, Wagener, space Jerry Spence, and you'll find it.
Okay, well, there you go. All right, so
what's the next page we have on 1215.org?
Well, I want to say one more thing about a court of record.
Okay.
The word, you know, if you have a business, let's say that you fix tires, okay? Fix flat tires. And now somebody comes in and they want their tire fixed. Would you refer to that customer as a patient of yours? I don't think so. Right?
No.
He's a customer, not a patient. The medical profession, for all practical purposes, owns the word patient. Okay? Well, in that same sense, a court of record owns the word record. Say to the clerk, I'd like to see a record of the proceedings, you know, where they list all the decisions that are made and what papers are filed and that sort of thing. She will hand you a list, and the list will say Registry of Actions. That's typically. Or it'll say docket. It's a docket sheet. It never says record. Why? Because the equity courts do not keep records. They do keep a list, and the word does get abused. People tend to call it record, but in reality, the court of record owns the word record. Only a court of record keeps a record. Okay?
Copy of minute order means what?
Now that's a different story. A minute order is not in that list. A minute order is a clerk's note. And first of all, although you're saying minute order, the actual term is minute order. Minute meaning small.
Right.
You see, back in olden days, before we had typewriters and machine printing, everything was handwritten. A court order was always written in a large hand, big letters, big, okay, on the page. The clerk's notes were kept in a minute hand, meaning a small writing. So a minute order, see, the problem is that in a court of record, in California example, all of the courts are superior courts, right? A superior court, a true superior court, is a court of record. But they are equity courts. Equity courts are not courts of record. So when the judge of an equity court, if he wants it to be like a court of record, but he doesn't want to violate the rules, he will issue a minute order instead of an order. He can't issue orders in a real court. So he issues minute orders, clerk's notes. So a minute order is not actually an order. It's very effective as an order so long as everybody obeys it. But what if somebody says, wait a minute, that's just a clerk's note, I'm not going to obey that. Now they have a problem with it, with a court of record. Of course, they run it as equity courts, and in equity courts, that's a whole different game. And I'll get into that a little later. But right now, I want you to know that a court of record has those 4 requirements, and it may or may not have a seal. So you don't have to have a seal for a court.
Okay, those 4 elements are, briefly?
The 4 elements are, it has power to fine or imprison for contempt. It keeps a record of the proceedings. It proceeds according to common law procedure. Now that doesn't mean it's applying common law. It can apply many different kinds of laws, but the procedure is a common law procedure. And then the 4th requirement is the tribunal is independent of the magistrate. All judges are magistrates. If you look at California Code, the Penal Code, Section 808, specifically says that all the judges are magistrates. Okay? And so the tribunal, that's the one who does the judging, is independent of the magistrate. So that means that a magistrate cannot issue any orders whatsoever. Okay? His job is to direct traffic in the courtroom, who gets to speak next, and there's a specific procedure to follow. So he can't make any judicial decisions in a court of record. However, in an equity court, the judge is like God. He can do anything. He can enforce the rules, the codes. He can change the codes. He can suspend the codes, or he can make up his own rules. He has actual authority to do that. So people go into court a lot of times, they're equity courts, and they think they got a raw deal, that the judge broke the rules. No, he didn't break the rules. He's authorized to change the rules. That's normal. And hopefully we'll have time, I will explain that later. But let's see.
Unwritten rules in court?
Yes, there are some unwritten rules, things that are established by centuries of custom, okay? For example, you don't wear a hat in the courtroom. You stand up when court comes in session, okay? Those are unwritten rules. You go to court well-dressed. You don't look like a bum. These are all unwritten rules, and they're enforceable, okay? And the judge will say you're disrespecting the court and find you in contempt of court if you refuse to do those things. And it's not a big deal. Some people are afraid that they're somehow granting jurisdiction to the court because they stand up, so people refuse to stand up when the court opens up. All it does is create distraction, irritation on everybody. It's not a good deal. And it's totally unnecessary. So when you address the court, you do not speak to the opposition. You don't face the opposition and talk to the opposition when you have some contention. If the opposition says something, you don't object to that person. Instead, you object to the judge. You face the judge and you speak to the other person through the judge. That's just a custom. I've never read it in the rules anywhere, but I know that's how it works. You know.
Court etiquette, I've seen it.
Yes. So that's very important to be well dressed. As you can see, I'm dressed the way I dress now. I'm dressed the way I dress when I go to court.
You worked for court today, but you didn't say a thing on the court record.
That's correct.
You just sat and observed.
That's right. But if I were a party or participating in the action, you would think I was an attorney by the way I dress, but I'm not.
Right.
Okay? And it's important. I mean, your image, in fact, I highly recommend reading a book called Dress for Success by John Malloy, M-O-L-L-O-Y. John Malloy was an engineer who got invited to study clothing and how it affects what people think of you. And he did actual practical tests to prove the effectiveness of different types of clothing in different situations. So I highly recommend reading that. Okay, now we have a document. How much time? I don't have much more to say, actually.
Okay.
But we'll talk about the Magna Carta. Now the Magna Carta, what happened was that King John was conducting his private wars, particularly against France, and he was drafting or confiscating funds from the nobility, and as well as taking their personnel to make them into soldiers. And they got tired of that. So one day at Runnymede by the River Thames, they trapped the king, and they said, we have this little document for you to sign. If you'll sign it, we won't cut your head off. And so he signed it. Later, they got the approval of the Pope. Now, both the king and the Pope were politically weak at that time, and they couldn't exactly say no, but on the other hand, they did not intend to honor the Magna Carta.
Well, it was signed under duress of having his head cut off.
Well, duress or not, their signatures were on the paper, okay? Now, were politically weak at that time, and they couldn't exactly say no, but on the other hand, they did not intend to honor the Magna Carta.
Well, it was signed under duress of having his head cut off.
Well, duress or not, their signatures were on the paper, okay? Now, this idea that if you sign something under duress, it's no good, that's fine as long as you have a higher power enforcing that rule. But we're dealing with the higher power, okay? I mean,
right.
by that argument, no war would be valid, which is probably true too. But nevertheless, once the enemy is vanquished, then the winner writes the rules, right?
Exactly.
That's how it works. So anyhow, as luck would have it, both the king and the Pope died within a year and a half. And as a result, the new king and the new popes that came in, they were not politically established, but the nobility still were. And so they got the Magna Carta recertified and re-blessed. And every king or queen since then has recertified the Magna Carta. Now the Magna Carta has a lot of good stuff in it, some very interesting stuff. For example, no cop can be a witness. He has to produce 2 witnesses who are faithful. That means they don't work for the government, okay? So this is just one of the interesting requirements. No cop can take a person's carriage, horses and carts, for his own use. Of course, the modern horses and carts are called cars, okay? Is that a problem?
Well, he can't take it for his own use, but they often have it impounded.
Well, that's for state use, isn't it?
Yeah.
Well, that's the king's use. I mean, you know, Magna Carta restricts that. He has to get your permission. So, obviously, we have a lot of rules that don't go along with the system as it was originally intended. So.
Now, the Magna Carta is law in the United States, even though it dates back to...
Yes, it is.
1215?
Yep.
But long before the United States or the colonial states of America existed, and yet you say it's part of our Constitution. Why? Because Article 7 specifically uses the word common law?
Yep.
Article 7 of the amendments, I should say.
As a matter of fact, anywhere you see the word law in the Constitution, if it's not modified by an adjective, it means common law.
Interesting.
So, for example, in Article 3 of the Constitution, which deals with the judicial branch, it says that in all cases in law and equity, okay, blah, blah,
yeah,
blah, whatever. So it's yes, the law is the common law, and it means the common law of England, as it was in 1776. Well, in 1215, the Magna Carta came in, it was signed, and then in the year 1297, I believe, there was the Confirmatio Cartarum, and it was signed in the year 1297. Okay, as a matter of fact, today's the 9th?
Yes.
Okay, well tomorrow, October 10th, is the date that the Confirmatio Cartarum was signed in the year 1297. October 10th, 1297. So,
that's 700 years of common law.
More than that. 722 years. So, and it says,
yet you almost never hear a judge refer to common law in court.
Well, that's because you're in an equity court. See, when they first put together this system in the United States, one of what I feel is a mistake, one of the mistakes they did is that they combined the common law court and the equity court. They put them both under one judge. So now the judge can switch back and forth. Half the time you don't know where he's sitting. Okay? So that's a problem we've got with that system. In the common law court, well, not just common law court, but the court of record, which is proceeding according to common law. In a court of record, the judge has zero authority to make decisions. In the equity court, he has unlimited power to make decisions. He can even change the laws. Not really law, but he can change the rules, such as statutes and codes. Now let me go into a little bit of how this comes about. Back in England, they had the King's Common Law Courts. Now the King's Common Law Courts absolutely went according to black letter law. In other words, it had to be in print. That was the law. And there was no other law unless the king printed it and gave it to the judges. The judges had absolutely no discretion. All they could do was apply the common law as defined by the king. Well, in those common law courts, you could only sue for money. You could not sue for anything else. So if your house was going to be bulldozed by somebody, you had no way to stop them. You could sue them for money to replace it, but you could never replace the house itself. So that would be an irreparable harm to you. No way to fix it. Only a way to get paid for it. So what you could do in those days, you could go to the common law court and you would request a writ. Now the word writ means order. So you could request an order where the court would issue an order allowing you to go to the king in order to get justice, because you had no other remedy at law. The only remedy at law was money. So since you had no other remedy at law, you went to the king so that the king could look at your case and make up a decision on the spot. It would be a one-case law. Well, the king was a busy guy, so he had a right-hand man called a chancellor. The chancellor had all the powers of the king, could do anything the king could do, with one exception, and that was that the king could reverse him. The king was the highest authority. So the chancellor himself was busy, so he had sub-chancellors. And in England, they developed a system of courts called courts of chancery. When that whole process came over to the United States, the courts of chancery became known as equity courts. So now you have equity courts and law courts. That's really chancery courts and law courts. Okay? So here you have it. Now remember that the concept they're following is that the king is there by divine right. So the king was in position by divine right. So meaning that God put him there. That's why he's king. And of course, the king could do no wrong. And remember, if the king violated his own law, he really didn't violate it. All he did was change it for the moment. Okay? Because the king was the source of everything. So the question was, or is, well, what's the authority? Well, in the case of a common law court, you have the court of record. The judge has no authority to do any thinking. But if you're talking about equity courts, then the judge has complete authority. He can do anything he wants, really, because he is the voice of the king, unless the king overrules him, such as you have appellate courts, right? You have supreme courts, and then you have the court of the people. That's the court of record. So the court of record is the highest court of all. It's even higher than the Supreme Court. As a matter of fact, I left that out, and I think I should read to you something very important here about the court of record.
Okay, go read it. We got it on film already, right?
Not this part. Let's see. Here's what this is what the Supreme Court said in one case. It was Schneckloth versus Bustamante. Okay, 412 U.S. 218 255, and that was in 1973 when this was quoted. The actual case was earlier, I think, but it said, "The judgment of a court of record, whose jurisdiction is final, is as conclusive on all the world as the judgment of this court would be. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding it.
Got it.
So that the court of record is the highest authority. You make that decision, not even the Supreme Court can change it. See? So that's really very important. And also, I want to read this other decision. What's the difference between a superior court and an inferior court? Okay? So it says, the only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the superior court and no presumption in favor of the judgments of the inferior court.
And what would you say is a superior court?
A court of record.
Court of record.
That's the only superior court. All other courts are inferior courts.
I noticed Dan, the man today, had his audio device and he was always making a record. When they started, when they finished,
technically that's not a record, okay?
But he had his own record.
He was making a recording on audio recording, but that is not a record. The only record is the record that's kept by the clerk in a court of record, and that all that shows is what proposition was made to the court and what decision was made on it. That's it, just those two things.
Got
Okay?
it.
Everything else is just maybe notations, and we loosely refer to it as a record, but that's an incorrect term. Okay?
So the only thing that is record is what motions were put forward to the court and what the court's decision was.
That's it.
Everything else is called pablum? Fluff.
If you want.
And the judge says, I'm terribly sorry, I'll take you out to lunch tomorrow, but I have to rule this way.
Yeah.
Taking you out to lunch and all that
Sure.
has no effect.
Nope. Nothing. Okay?
Okay, what's next?
All right, so
I think we've gone through all the pages, haven't we?
pretty much. We do have, I want to talk about the Confirmatio Cartarum, because that's very significant, and I want to read a significant part of it right here.
Okay.
It's the very first paragraph of the Confirmatio Cartarum. In English we say the confirming charter. And it was by King Edward I in the year 1297. And in his first paragraph, toward the end, he says, the foresaid charters to be published, meaning the Magna Carta. And he declares to the people, to all our other officers, and to all our cities throughout the realm, together with our writs, that we have confirmed them in all points, and that our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points. That is, to wit, the Great Charter, meaning Magna Carta, as the common law. So, if a person goes before a government official and says, my law is the Magna Carta, that's the common law, and the official is required to accept it. And we inherited that common law in 1776. Actually, it was brought over, it was the law of the land here before 1776. But when we formed our new country, we accepted the existing common law. And so,
how do we know that we accepted it?
it's written, it's codified. I know that when I was in Colorado, I looked it up, and there's a whole section in the code saying exactly what the common law is. What they actually goes back to the orders issued by kings in the past. So, but here we have the Confirmatio Cartarum, which makes it very clear. The Magna Carta is the common law if you demand it. That's important, if you demand it.
And Can you demand it at any time, or do you have to demand it right at the beginning of a proceeding?
Well, it could be any time, but I'll tell you something, I would demand it at the beginning. You know, I wouldn't wait.
Yeah, when they're about to put the blindfolds on and have you step into the scaffold for hangings a little late.
Well, not quite, because there is a court case, I don't have it handy, but in which the court said that the question of jurisdiction can be raised any time before or after judgment. So.
And that case is, which case? It's on your website?
I don't know if it's on the website or not, but I do know that there is such a case.
Do you remember the year of it?
Nope.
Okay.
It's a modern case, but you know, it has to be in the last century.
So we've covered all the web pages?
Well, there's a little more to this. For example, on the website, we do have an actual example, and on that second page, you know, after you click on Start Here, on the second page, when you get to the end of all the links, there's right at the end, there's a link which says Example, and you click on that, and you'll get the actual transcripts. This had to do with a case where the judge made some decisions. The plaintiff then issued a writ of error canceling the decision and finding the judge in contempt of court. And then we have a transcript of how the judge talked after he was found in contempt. It was very interesting. You can see the contrast of the before and after he recognized the authority of the plaintiff. So that was interesting. Also, there's another final link on there, 1215.org/Q, as in Quebec, the letter Q all by itself. And that has another example, and it also has a suggested strategy that a person could use in making counterclaims and such. So that pretty much kind of is an overview.
Okay, I have a question.
Sure.
In 1810, the first central bank of the United States charter expired. And it was a hot political potato to renew that charter at the time. There were many business people who lost their ownership of whaling ships because their loan was called in without much notice. And nobody was really, among the average people, nobody really knew who the first charter was owned by. Turned out it was owned by foreign banks. This led to, I'm summarizing, but this led to a call for a 13th Amendment. At that time, in 1810, there was only 12 amendments called the Bill of Rights, or the first 10, and then there was the 11th, and there was the 12th, and so they ratified by states in 1812, I believe, it was finally ratified. Virginia shows it on its books. And at that same time, coincidentally, there was the War of 1812. Well, and then the records were burned.
Sure.
But the people that marched in wearing red jackets, just like the British redcoats, when they burned Washington, D.C., apparently they did not stop and think that each of the states, the sovereign republic states, were keeping their own copies of their state constitution, their state laws, and the federal. And sure enough, I have obtained 4 books that date almost 200 years old that show the original 13th Amendment. I've never found anything that repeals it. So is that still a valid law?
Well, first of all, there's theory and then there's practice, okay? And a lot of times those two don't coincide. So you'll find plenty of examples where laws were created but not enforced. You know, that happens pretty regular. I know that they have what are called blue laws, which are ridiculous laws that are on the books. I know there's a law against bluebirds singing on Sunday in one place. They got all sorts of silly things. But they also have real things, like there's a provision in the Constitution that says you have to have a census every 10 years, okay, which is carried out. But in that same paragraph, it says that on the in-between years, that the census, not the census, but the assignment of representatives shall be in accordance to who votes, how many votes each state has. That's never been enforced. Okay, never. Now, how long do you think the black people would have been prohibited from voting if that law had been enforced? Okay, so that's a practical example, and it requires the cooperation of everybody to ignore it, and nobody felt it was important enough to make an issue. And then, for example, the state of Ohio, is it really a state? I know it wasn't a state for a while, and then I think it was 1957, up until 1957, they treated it as a state, they recognized it and everything else, but there was some defect in how it became a state. So they tried to fix it in 57, but then that wasn't legal either because the Constitution prohibits retroactive laws.
Well,
So,
I know the Constitution prohibits it, but in California here, when now ex-attorney Richard Fine found the county of Los Angeles taking bribes, all the judges taking open bribes in violation of a law that dates back to the 1980s,
sure.
the state legislature convened and just said, oh, we're going to call that extra pay, incentive pay, and they
Right.
passed SB X 211,
Of
making it retroactively legal for these judges
Right,
to be bribed by the corporations of the county.
right. Well, see, again, you're
So-
getting involved with the real world, okay? And
But I mean, isn't that proof that we no longer have a republic?
no, what it's proof of is that the real world doesn't always match up with theory.
Okay.
So you have, it's imperfect. It's not totally, it's not a total failure, and it's not a total success. What it is somewhere in between on the grayscale, okay?
So how would you interpret the meaning of the original 13th Amendment of 1812?
Well, that 13th Amendment, sometimes called the Lost Amendment, Lost 13th Amendment, it's very real. I mean, people have done their research, they gathered the information, they checked it out, and it did get ratified. However, it's like, you know, if you have a ship on the ocean that's traveling and you want to turn it around, you can only turn it around by a degree at a time. You can't do a flip. And that's the problem you have with a large organization. It's a problem of education, it's a problem of convincing people to all go in the same direction. That's the real world. You can't expect perfection, okay? You're
Right.
just going to have to deal with that. And it goes back to early on. You remember I mentioned that if you're a pedestrian going to cross the street, you see a car coming, should you enforce your rights and get killed, or should you just let the car go by? Okay? So there's a lot of power there that's beyond your ability to control. It goes back to recognizing what you can change and what you can't change, and the wisdom to know the difference. So accept that things, it's just like a color scale. You have black and you have white, and then you have a gray scale in between. You know, how dark is dark? So, and it's a sliding scale of enforcement of the law. We do what we can, but it's not perfect.
Why would you, have you got any opinion as to what the real import of the original, or sometimes called hidden 13th Amendment, what it was meant to do?
Oh, it's very important, but again, you don't have the power to enforce it. You know,
But
even if you...
My question is, what was it meant to do?
Well, I think it was meant to limit the power of the attorneys. Let's get rid of the attorneys. You know, in the early days of this country, attorneys were outlawed. They weren't allowed.
Yeah, most counties in Virginia and most other states banned attorneys from entering the courtroom.
Right, right. And not only that, but they were banned from collecting fees for their advice. But you can't run a legal system without having advice, and people are not willing to work for free. So eventually, you had to have paid attorneys. I mean, there's no way to avoid it, as far as I can tell. It's a necessary evil.
Let me stretch beyond our subject matter here. I think you've covered the common law and your website, 1215.org, very well. Let me stretch a question. Would it be fair to say that the attorneys claim privileges which the original 13th Amendment was intended to prohibit? They claim the right to speak for you better than you can speak for yourself. They claim the right to do things that the average person is not allowed to do.
Well,
Would that be a fair statement?
They didn't have to claim it. They on that particular point, they didn't have to claim it at all, because that's all part of the system we inherited from England. If you get a barrister to represent you in England, you can't talk. He talks for you.
Right.
That's look.
Would it be fair to say the Bar Association and all their attorney members are enemies of their hidden 13th Amendment?
Well, yeah, they don't want their authority to be diluted, of course.
It's pretty obvious, isn't it?
Yeah, well, of course.
So when you ask an attorney, is there such a thing as a hidden original 13th Amendment, they'll say, no, that's all hocus pocus.
Sure.
But I have 4 volumes that the books are not copies. They're the actual original books.
Yeah.
From almost 200 years ago. And there's a 13th Amendment long before the end of the Civil War.
Right.
And the attorneys, I just showed it to 2 disbarred attorneys, and both of them went to prestigious law schools. They both said, wow,
yeah,
I've never seen or heard of that.
Right. And like also the 14th Amendment, you know, this fellow went around and he wrote a book called The Law That Never Was.
Bill Benson.
Yeah, and there it is. It's very clear that they did not properly pass it, and yet there it is. It's recognized.
And
So,
they put Erwin Schiff in jail just for writing The Federal Mafia.
Right.
I mean, I never heard of a person going to jail for a book that has no pornography, does not call for the violent overthrow of the government.
I know.
But Erwin Schiff did.
But again, you see, this is a problem that a lot of people have. They look at the black letter of the law, and they read one thing, and then the real world works differently. And believe me, you've got to contend with the real world. And so, and remember this also, that law follows power. So until you have the power to enforce the law, you don't have the law, okay?
Right.
So it's a political power. It's really a political question. So you're dealing with a ship that you're trying to change the direction immediately, and you can't do it. You got to do it a degree at a time.
Well, thank you very much, Bill Thorton.
You're welcome.
Expert extraordinaire on the common law.
I'd like to add one more thing, that my name, Thornton, has a history. The first barrister who came to the United States was named Thornton. And the first barrister to be deported from the United States for jury tampering was the same guy, Thornton.
Wow.
Also, I
did not know that.
Also, there's a legal trial technique. You can have trials as we know them, or you could have a trial by battle. It's still a legal concept, okay? However, the last time that was brought up was in England, where this guy had, obviously, he was accused of murdering a woman, and when they went to put him on trial, he challenged his accuser to a trial by battle, which meant the winner, if he won, he was innocent, and if he lost, he was guilty, right? And it turned out that he was so big, nobody would challenge him, and his name was Thornton also.
So if you're bigger than the judge, and they call you into court and accuse you of some heinous crime like not paying your
it's not the judge.
Income taxes.
It's not the judge.
Or the prosecutor.
It's the accuser. The accuser.
Yeah, the accuser. You can challenge the accuser to a trial by battle?
Well, in theory.
I thought after Aaron's and Burr's duel, they passed a law ending trial by battle.
I don't know if it was trial by battle or ending duels.
We'll have to research that.
Yeah.
Interesting.
But of course today it's not going to happen. I mean, you can challenge all you want by battle, but it ain't going to happen.
I don't know. There's some judges, little women judges, I would like to challenge to a trial by even in my old age. Trial by battle.
Yeah, I'm sure it's trial by wrestling, yes. I understand, but that's a different story.
Okay. Well, thank you very much for this interview, and thank you for your website and all the effort you put into 1215.org.
Court of record, whose jurisdiction is final, is as conclusive on all the world as the judgment of this court would be. It is as conclusive on this court as it is on other courts. It puts an end to inquiry concerning the fact by deciding it. And that's ex parte Watkins, 28 U.S. 193 and 202 to 203. That's an 1830 case, and it got cited by Schneckloth versus Bustamante, 412 U.S. 218 and 255, a 1973 case. Are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. That's ex parte Kearney, 55 Cal 212, and Smith versus Andrews, 6 Cal 652. Those are California cases. So if it's not according to the common law, it's an inferior court. Then the other one is the only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the former, none in favor of those of the latter, and that a superior court may be shown not to have had power to render a particular judgment by reference to its record. Note, however, that in California, superior court is the name of a particular court, but when a court acts by virtue of a special statute conferring jurisdiction in a class of cases, it is a court of inferior or limited jurisdiction for the time being, no matter what its ordinary status may be. That was Haydenfeld versus Superior Court, 117 Cal 348 and 49 Pacific 210, and Cohen versus Barrett, 5 Cal 195.